Hello and welcome to Cleaver Fulton Rankin's webinar, Using Legal Services to Construct Your Way Through the COVID-19 Pandemic. My name is Lisa Boyd and I'm a director specialising in construction and procurement law. I jointly head up our construction and real estate sector team along with Catherine Colley, who is on the panel today. I have the pleasure of being your host for today's webinar. Firstly, I would like to thank you for taking the time to watch this. I hope that you will find the legal solutions offered today of assistance over the forthcoming months as you seek to construct your way out of the COVID crisis. Undoubtedly, the COVID crisis has had a devastating economic impact across all sectors, and our construction clients are using our legal advice to navigate through this new business environment. To date, we have been advising on a whole host of construction issues, including PGN supplier relief, early warning notices, compensation events, and force majeure. We have drawn from our vast experience across our specialist practice areas and designed a series of solutions to support your construction business needs. Our legal services can help you to improve cash flow, maintain company stability, and increase your revenue. If that hasn't grabbed your attention, before we kick off our webinar, I want to let you know about our brand new construction business audit, which our team has designed to help you understand the key strategic issues you should urgently be addressing to ensure you're in the best shape to navigate the weeks ahead. Please visit cleaverfultonrankin.co.uk/COVID-19 to access this audit. Now on to today's webinar, over the course of which we will address some topics which are also covered within our construction business audit, including employment, real estate, company structure, and contracts. We may not answer all of your questions in this webinar, so please do take 10 minutes to complete the audit and we will be in touch to address any specific issues your business may be facing. Alternatively, contact us using the contact details which can be found at cleaverfultonrankin.co.uk/people. So let's get started with the introductions. Joining me on our webinar today, we have four Cleaver Fulton Rankin directors. Catherine Colley, who is the Director of Commercial Real Estate, Aisling Byrne, Director of Employment and Data Protection, Jeanette Donoghue, Director of Insolvency and Business Restructuring, and Patrick Fleming, who is the Director of Dispute Resolution and Construction. Welcome everyone and thank you for joining me today.
Morning, Lisa.
Hello.
Hi, Lisa.
As co-head of the unit, Catherine, I hope you don't mind if I start with you. One development which affects every construction company is working at home for office and professional staff. With working from home having been implemented virtually overnight for most office-based staff, what options are now available to landlords and tenants to reassess their property interests?
Thanks, Lisa. Well, I'm sure we are all aware of what a huge sea change there's been in the working environment over the last few weeks and months. The question, though, is that when we are able to get back to work, what's the likely impact that that's going to have on our workplaces? So if you're a tenant, the big issue is likely to be one of space. There's been various studies done over the last number of weeks showing the huge success of working from home and the likely effect that many employees are not going to want to go back to the traditional 5 days a week working in the office. So you might consider that you're going to have too much space. What can you do about that? You need to look at your lease and consider what options you have. One of the likely scenarios is that you might be able to sublet part, for example. That will be subject to conditions, restrictions, and more than likely consents needed under the terms of your lease. So you need to be aware of what it is you need to do to process that. You might also, depending on the physical layout of your property, be able to agree with the landlord that you'll surrender back part of it. But that would be strictly subject to agreeing terms with the landlord and more than likely involves some form of payment back to them, depending on how long if your lease is left. You might be lucky enough also to have a break clause in your lease that you can still implement. If you do, it's very important that you look at the terms of that as to when you can exercise the break, how much notice you need to give, and also what conditions are going to apply for that break to be effective. But even having a break clause actually can be very beneficial to you because it allows you to have a conversation with your landlord about if I don't want to exercise this break, can you come back to me and sort of offer me more attractive commercial terms going forward? So there is a definite benefit there. The other big issue I think for tenants is obviously one of rent. We're seeing a lot of conversations at the moment between landlords and tenants discussing rent concessions, rent deferments, rent holidays. The important point there is that if you do manage to agree something with the landlord, is to get it properly documented. You need to be sure that you understand what you've agreed, how long it's for, and is there any likely impact on your lease terms going forward. So turning now to landlords and developers, I think they're going to have to be more flexible in bringing their schemes to market. Even if they've already got a planning consent in place, I think they should be looking at it to see if it's still fit for purpose. So we've already seen some residential schemes being amended so as to try and squeeze in an extra bedroom, for example, to allow people to work from home. The modern trend for large open plan spaces may be less attractive now going forward for purchasers. So I think developers again might need to look at repurposing things to allow partitions, to allow people to have a private space to cut themselves off from the rest of the family. All of this though also does involve the planners. And I know it's been said many times before, but I think we need a speedier planning process. So again, developers, I think, need to be engaging with the executive and collaborating also with the local authorities in order to make sure that the planning schemes that they are bringing forward are going to work, that they're going to be profitable, and that can maximise growth for them. So the final point really is, I think if COVID-19 has shown us anything, it's shown that people will want flexibility in both their working and their living arrangements. So I think the debate on the work-life play has still a wee way to go.
Thanks, Catherine. No doubt that will have been of interest to everybody watching, as it has the potential to affect both landlords' income and the outgoings for commercial tenants. That takes us neatly on to a question which hopefully Aisling, you can address. A few months ago, furlough was virtually an unknown aspect of employment law, and now even my 4-year-old daughter knows what it is. As I understand, further information was released on Friday, the 29th of May, in relation to the job retention scheme. What are the main points that construction employers should be aware of?
Thanks, Lisa. Yeah, I mean, I don't think anybody in the UK had heard the word furlough until March. I think it's a term that was used in the US years ago, but as you say, it's now tripping off everybody's tongues, particularly in the construction sector, because I think we all appreciate just how badly hit it has been during this crisis. I saw a headline yesterday, the Office of National Statistics released information that said that the construction industry was second only behind hospitality and food in relation to the total hours worked in the first 3 months of 2020. So that'll give you an idea of how valuable the furlough scheme, the job retention scheme, has been to the construction industry. And so we knew that the scheme was going to continue until the 31st of October. That had been announced a couple of months ago, but we didn't know exactly what the mechanics of the scheme would look like. So thankfully we have a bit more information. And I don't think the changes were as drastic as had originally been anticipated by industry sectors. So that's good news, certainly from the construction sector that's just getting itself back on its feet. I know that a lot of the construction sector has started to resume work, but there will be situations where they can't bring everybody back. And so I think the construction sector is still relying heavily on the job retention scheme. So if we look at the announcement of what that means and take it month by month, in June, the scheme is going to continue as is. So the government is going to continue to contribute 80% of an employee's salary up to £2,500. So that's good news. But the bad news is that the last date on which employees can be put on furlough is the 10th of June. So if employers are going to act, they need to act very quickly. If we move on into July, the scheme is going to change slightly. And the government has introduced this notion of what's called flexible furlough, which means that employers can bring employees back part-time and then avail of the furlough scheme for the balance of the working hours. So that certainly has advantages for the construction sector. If you think about it, and a site is reopening, but it may not be operating at the previous level. They may only need people to come back on a part-time basis. The construction employers can use this scheme and claim for the remainder and the balance of the working hours. So certainly that's an attractive development. And again, in July, the government will continue to make that contribution of 80% of wages up to the £2,500 level. So things are going to change slightly again from the 1st of August. Employers are going to have to make a contribution to cover employers' national insurance and pension contributions. So the idea is that slowly this scheme will taper off. And again, then moving into September, employers are going to have to make a contribution of 10% towards that 80% cover. So again, it's the winding down of the scheme, and employers are going to have to cover the employer's national insurance and pension. And then into October, the contribution from employers is going to increase to 20%. And then the scheme is going to actually come to an end by the 31st of October, in the hope that the sector will be back on its feet and things will be operating again. So hopefully by the 31st of October, everybody will have availed of the scheme, and it's being useful. The idea behind it is that it'll keep people in employment for as long as possible, and it's certainly been a lifeline, particularly for the construction sector.
Thanks, Aisling. It's obviously very important then for employers to be aware of that date of the 10th of June and going forward to utilise all the new flexibilities that are offered by the scheme. Jeanette, then, given that the construction industry was only starting to see green shoots after the last devastating recession before this new blow, can you explain what new reliefs will be available for struggling businesses following the implementation of the Corporate Insolvency and Governance Bill?
Yes, Lisa. The Corporate Insolvency and Governance Bill was introduced into Parliament on the 20th of May 2020, and it proposes changes to existing insolvency law and company law in respect of businesses struggling as a result of the COVID-19 pandemic. The bill will provide vital support to businesses trading with limited resources and under lockdown restrictions, introducing both temporary and permanent relief options. So dealing firstly with the permanent relief options, there is a new company moratorium available for businesses who are unable to pay their debts or will very soon become unable to pay their debts as a result of the current situation. With the assistance of lawyers, directors of a company can complete and lodge forms at the High Court in Belfast, creating a 20 business day moratorium around the company. The idea is to give the business a bit of breathing space to consider a rescue plan. The moratorium can be extended to up to 40 business days and possibly beyond that if a formal insolvency process is put in place. During the course of this moratorium, the directors are still in control and continue to run the company, but this is done under the supervision of a monitor who is a licensed insolvency practitioner. The second change is that the bill affects termination clauses in relation to supply contracts. Now, I would say that these provisions are particularly complex and you should consult a lawyer if you find yourself on either side of them. On a high level, however, it introduces a disapplication of the rights of a supplier to terminate a contract as a result of a company's insolvency. Subject to certain exceptions, suppliers will need to continue to supply goods or services to an insolvent company, even when that supplier may be owed significant sums of money by the insolvent company prior to its insolvency. So this applies to businesses who have entered into insolvency or a restructuring procedure or has obtained the moratorium which I've just mentioned. The business is required to pay for all supplies going forward once it is in the insolvency process, but it is not required to pay outstanding amounts due for past supplies whilst it is arranging its rescue plan. So it's foreseeable that this will give insolvent companies an additional tool in which to trade through a restructuring or insolvency process and increase the chances of a solution being found for the business. The bill introduces changes to the method and forum for the holding of annual general meetings or general meetings where the company's constitution would not normally allow for it. For example, there is the ability to communicate electronically as opposed to have to attend meetings in person, and these measures apply retrospectively from the 26th of March 2020. The bill also introduces a new option for businesses needing to restructure the liabilities, which is called a restructure plan. So this restructuring plan is in addition to the existing mechanisms in place under the Insolvency in Northern Ireland Order 1989, such as a voluntary arrangement. The plan will enable complex debt arrangements to be restructured and will support the injection of new rescue finance. This new court-based plan will allow a company to bind all of its creditors to it, including groups of dissenting creditors. However, it will require final sign-off by the court. So turning to the measures now, which are more temporary in nature, there's a temporary suspension in respect of wrongful trading. So for the period from the 1st of March 2020 to the 30th of June 2020, directors of companies who have continued to trade during this period, which has resulted in an increase in creditors, will not be subject to wrongful trading proceedings. This is where directors can be personally liable for amounts due to creditors if they continue to trade when they knew or ought to have known that the business was insolvent. And there's also a moratorium in respect of presentation of winding up petitions to the 30th of June 2020. Our Chancery Office here at the High Court in Belfast has not been accepting winding up petitions since the 12th of May in any event, irrespective as to the timing of this new bill coming into force. So the amendments proposed by the bill will be welcome and should go some way to reduce the pressures on businesses continuing to trade during this uncertain time.
Thanks, Jeanette. Whilst insolvency isn't something that companies like to think about, it's good to know that in the current circumstances, there's protective measures in place. Patrick, moving then on to core construction concerns, could you walk us through the possible methods to gain compensation in respect of COVID under NEC and JCT?
Really, so no problem at all. COVID-19 has obviously caused significant disruption to many construction projects. A lot of them are site-specific to the extent of that disruption, but it's caused issues in regard to social distancing, increased welfare provision on site, shortage of labour, and of course supplies. The supply chain has quite often been stopped as well. So two main things all parties to a contract will want to explore is a method of getting compensation. That is relief in the form of extensions of time or reimbursement for loss and expense due to the COVID-19 pandemic and what's been experienced. Under the JCT, a contractor is entitled to claim an extension of time if a relevant event causes delay to the progress of the works, and that is defined in clause 226. Now, there's a number of different relevant events that we've seen being advanced and argued, but arguably the strongest one relates to clause 226.12, and that is due to the exercise of statutory powers by UK government or any local or public authority after the agreed date, and the agreed date is normally the date of tender. Clause 226.6 may also be applicable, and that's where there's been any impediment, prevention or default by the employer, e.g. Prevention of working hours, restriction of working hours, or restriction on methods on site, or other site user restrictions or access restrictions. Clause 226.1 also may be applicable, and that relates to any change, which is also defined, and that is the imposition by the employer of any restrictions in regard to access to the site or limitations on working space or working hours. So it's obvious that all of these things could be fairly applicable to COVID-19. And finally, in regard to the JCT contract on relevant events is force majeure. And that's another term which almost has become as familiar as furloughing. My children now have a familiarity with that, which is slightly worrying. But the details of force majeure is worth a discussion in itself, and I'll touch on it again later. Under a JCT contract, all parties need to understand the difference between a relevant event and a relevant matter. It hasn't been particularly useful that they sound almost the same, but the relevant matter is what is the transition into getting funds through the contract. Now, if I take the example of the JCT Design and Build Contract 2016, the occurrences of a claim under this head is a lot more limited. So to satisfy the contract, the contractor also has to show that there have been changes instructed by the employer, and that's under clause 421.1, or there's an employer's instruction to postpone work under 421.2.1, or there's an impediment, prevention, or default by the employer under 421.5. So they're the ones that quite often will be the main interest of the parties, but you can see there's a lot more availability for claims for time under contract rather than actually getting recompense by way of funds. The NEC contract obviously has its own regime. The contractor is entitled to an extension of time and additional cost if a compensation event occurs. That's defined under clause 60. 60.119, if I quote it, is the most relevant one for COVID-19, and it states that a compensation event, the relevant event, is an event that stops the contractor completing the whole of the works or causes a delayed completion of the whole of the works by reference to the accepted programme, and which, firstly, neither party could prevent, and secondly, an experienced contractor would have judged at the date the contract was entered into to have had such a small chance of occurring that it would have been unreasonable for the contractor to have allowed for it. Now, I'll come back to that later, but the key thing there, and which all contractors should be aware and all parties should be aware, is that it must affect the completion date for the whole of the works, not just delay a part of it. That's the ultimate completion date. Another argument often being advanced under the NEC form of contract is a claim under the optional X2 provision. Now, as I suggest, it is optional and will not be in a lot of NEC contracts, but that relates to a change in law. But again, both parties should be aware that government guidance is not a change in law and may not trigger this relief. Finally, I briefly mention that the PGN 0120 encourages parties to exercise latitude and to deal as best it can with the current position. Now, the PGN 0120 and also guidance issued by the Construction Leadership Council would relate to public sector contracts. So both are encouraging public bodies to act responsibly and fairly to protect jobs and the economy more generally. And the PGN has also helpfully published a deed of variation to assist the parties in reaching that result.
Thanks, Patrick. So a number of options, and as we know, each case tends to turn on its own facts and any amendment schedule that goes with that contract. So probably best to seek advice at the earliest opportunity on each of those. Okay, now we're going to move on to our second set of questions for each of our panel members. Catherine, thinking about your earlier comments on commercial properties and office space, as part of the strategy of getting back to work, why should companies be reviewing their title deeds?
Yes, Lisa, so I'm sure the idea of looking at your property contracts and deeds, whether you own a freehold or leasehold land, probably fills most people with horror. They're probably safely in the bank or in a chub in your solicitor's office, but I think we would recommend that now probably is a good time to dust them off and have a look and just see if your property interests can be made to work better for you. So again, if you're a tenant under a lease, it goes without saying, but you need to know the terms of the lease. What does your user clause say? Is it wide enough potentially to allow you to sell off the property to someone else for a different use? Or could you take it back and then maybe repurpose it? You should be thinking as well of, do you want to renew the lease? And if so, it might be beneficial to have a chat with your landlord now, off the record, maybe earlier than you might normally do, just to see what commercial terms he might be prepared to offer you to get you to sign up. Specifically, if you're coming to the end of the term of your lease, you might also want to consider serving on the landlord a request for a new tenancy, but at a much lower rent. So you might also have guarantee and guarantor obligations under your leasehold structure. You might be able to negotiate your way out of those or get better terms from your landlord also. The other key point for tenants is that the lease is most likely to contain a covenant that you have to comply with all relevant legislation. So as employers are looking now to getting back to work, we're obviously having to comply with maybe new regulations about social distancing, etc., as Patrick's already mentioned. So that may involve some form of alterations to the premises. You need to understand what your lease says about being able to do that, how you go about doing it, who does it, who pays for it, and if you've still got a rent review under your lease, is that going to impact on your rent review going forward? So at a more general point, you also might want to consider just how your property is held. So organisations may want to try and restructure so that your different property interests are put into SPVs or separate property holding companies. There might be tax benefits for doing that. So all of these, I think, are reasons why you might want to consider looking at your property deeds, particularly now that you might have a little bit more time to do it. So as and when as a country we're getting back to work and back up and running, at least you're sure that you've done what you can to maximise your potential for growth.
Thanks, Catherine. Time to dust off the deeds then and see what steps need to be taken as soon as possible. Aisling, as we know, the construction industry essentially paused with the rest of the country, and then the welcome announcements came that construction sites could reopen as long as social distancing and site safety could be guaranteed. What should companies do if workers raise issue about site safety?
Yeah, we've seen headlines already, Lisa, I think, even in the construction industry, where unions have been up in arms about the lack of social distancing, the lack of protective equipment, etc. So it certainly is a live issue. And if I were a construction employer, well, what would my first step be? Well, I suppose it would be to think about what are my obligations as an employer. You know, under the Health and Safety at Work NI Order 1978, the basic duty is to provide a safe place of work for your employees. And there's also added protections for employees under the Employment Rights Order. So if employees have a reasonable belief of a serious and imminent danger to their health and safety, they can't be either subjected to a detriment or dismissed because of that. Now, it's quite a high threshold, serious or imminent danger, but you can see how, given the COVID crisis, there could be issues raised by employees. And the very, very important thing for employers to bear in mind in relation to those protections is that they are day one rights. So, you know, normally an employee will need 1 year's service to bring in an unfair dismissal claim, for example, but not in relation to that particular protection. So that can be particularly advantageous for employees, particularly if they don't have long service, who find themselves with health and safety issues. So I suppose that's the starting point. You know, think about your obligations and then look at what guidance has been issued. You know, we have the pathway to recovery that was issued by the NI executive. As you've said, Lisa, you know, construction sites are starting to open. But although, you know, public health is a devolved issue in Northern Ireland, we don't have industry-specific guidance in this jurisdiction. So I would recommend that construction employers look to what has been issued in England and the guidance that has been developed there. There is the 8 sector-specific guides, and construction and outdoor work is a specific guidance note that has been issued by the government. It's actually very useful. It sets out in a step-by-step way how employers should approach the return to work and how to manage health and safety. And I think the key element of that is a health and safety risk assessment. If anybody's looking for a health and safety template, there's one on the Health and Safety Executive NI website. But it's basically a case of looking at your workplace, thinking about what you need to do to implement the guidance. So the 2 metre distance, for example, looking at your canteen facilities, moving to a situation where you don't provide hot food. You maybe tell employees that they have to bring their own food. You stagger work start times, work finish times. You do a one-way system where employees come in one way and leave another way. You look at what protective equipment you need to provide. And even within that guidance, it talks about collaboration, trust, and joint problem solving. So it envisages a situation where employers are actually going to engage with their employees and their trade union reps. And so from an employer perspective, that is the best way to avoid health and safety issues becoming a major problem. If you're engaging with the unions and talking to your staff about what the potential issues are, and you're addressing them in your health and safety risk assessment, then it's a lot more unlikely that you're going to face grievances and complaints and health and safety issues, you know, from your employees. So I'd certainly say construction and outdoor work guidance, although it's an English document, is really the key document that construction employers in Northern Ireland should be looking at the moment. You know, it may be that further detailed guidance will be issued by the NI executive, but there's no sign of it at the moment. So that's the key document that I would advise employers to be looking at.
Thanks, Aisling. Definitely one that needs to be kept under review, given that the landscape is ever changing and the possible ramifications if employers get it wrong. Thinking then, Jeanette, about companies that are struggling financially as a result of COVID. If companies are unable to continue to service their debts to the bank, what is the bank likely to do?
Lisa, the contractual relationship which your business currently has with the bank will be contained in the facility letters, loan agreements, security and other documents which you have entered into. Therefore, I would recommend that you get a lawyer to review these documents so that the lawyer can advise you as to what's contained therein. The bank's options to seek repayment in respect of the debt will depend upon whether or not the facilities are secured or unsecured. If the credit is relatively small, it's likely to be the case that the facilities are unsecured, but for any larger amounts, it is more likely that the bank will have a full suite of security documentation with charges over business assets and possibly personal recourse against the directors by way of personal guarantees. If the loan is unsecured, then the bank can seek to obtain repayment by issuing a demand letter. And if payment is not made in accordance with the demand, the bank could issue proceedings in either the county court or high court to seek a judgment against the business for the full amount due. If the amount is undisputed, the bank could take a more aggressive approach and issue a statutory demand. And if that statutory demand is not repaid within 21 days, the bank could then proceed to issue a winding up petition if it's a corporate entity, or a bankruptcy petition if you are trading as a sole trader, to place that business into either liquidation or bankruptcy. Due to the current COVID-19 pandemic and what is due to become law, and what I've just mentioned earlier, is the introduction of the Corporate Insolvency and Governance Bill. And as I have mentioned, there is a temporary stay on winding up petitions in this jurisdiction and in England until the 30th of June 2020. If the bank holds fixed charge security in respect of the amount due, such as a charge on property, then the bank could issue a demand letter and proceed to appoint a fixed charge receiver over that property. The receiver has the power to immediately take possession of the property over which it's appointed. It will collect rent, it will take control. Ultimately, it'll place the property on the market for sale, and any sale proceeds will be then applied against the bank's debt. If the bank holds floating charge security, which is security over movable property, such as cash, stock, debtors, this is usually contained within a document called a debenture. And this security will allow the bank to appoint an administrator, which is an insolvency practitioner, and that practitioner will take control of the entire business assets of the company from the day of appointment. The administrator's duty is to assess the viability of the business as a going concern and decide whether the business or parts of it can be saved, or if not, to realise the assets of the company for the benefit of the creditors as a whole. I would stress that the appointment of a receiver and the appointment of an administrator can take place immediately upon the expiry of the period of time in any demand letter which the bank gives to you to repay the loan. I have seen this to be as short as 24 hours notice. Therefore, if you do receive a demand letter from your bank, you really do need to seek advice from a lawyer immediately, as failure to act or engage with the bank could lead to an immediate loss of control of your business and business assets. You need to be careful if you've signed a personal guarantee in respect to facilities, the bank could call in the guarantee and you personally could be asked to repay the money due by the business to the bank. It is therefore very important that if you feel that you may be in breach of the terms of your banking facilities now, or could be in the near future, that you seek advice from a lawyer as soon as possible, as breaching the terms of your credit arrangements could really have a devastating impact on your business. Early dialogue with your bank could open up avenues to restructure loans, extend repayment terms, increase your facilities to allow you to continue to trade and ultimately save your business, which may not be available if you do nothing and bury your head in the sand.
Thanks, Jeanette. I think that will probably be useful information for a lot of people who are watching this, because so many companies out there have been badly affected by the crisis. Now, Patrick, our last question. For anyone who is thinking about entering into a new construction contract, are there any additional considerations? Will COVID still fall within force majeure clauses?
Thanks, Lisa. Ultimately, it'll be largely dictated by where the parties are in terms of the procurement or the negotiation of the contract, also by the unique circumstances that apply to each contract in question. The main issue, as with all contracts, is how the parties apportion risk. And in this scenario, it's how they apportion the risk now known with COVID-19, and also what is not yet known with COVID-19 and how it's likely to develop over the next 6, 12 or 18 months. So the parties have to decide how they wish to deal with that risk, both in terms of cost and time. And both sides may ultimately fall down to a question of whether that risk is worth taking and worth proceeding with the project on. COVID-19 has particular relevance, as you suggest, in regard to force majeure clauses or prevention clauses, as they're known under NEC forms of contract. It's important to note that force majeure is not a specific, or does not have a specific meaning under Northern Irish law or English law. It is a contractual creation, and therefore, yet again, dependent on the particular circumstances of each contract, the parties will need to develop that out and see how it best sits with their own unique facts and the stage they are at in terms of the negotiation. But if we look again at clause 19 of the NEC contract that I referred to earlier, it defines the event to be one that an experienced contractor would be considered to have such a small chance of occurring when the contract was entered into that it would have been unreasonable to have allowed for it. The parties obviously now know of COVID-19, so only the case law will show what they should have known at this stage. But it's obviously wise, depending again on the unique facts of the case, as you may well know, Lisa, to provide for it and what risks and the apportionment of those risks the parties are willing to take on an ongoing basis. Because certainly the stand-alone force majeure clause as it was drafted previously would invite arguments as to the state of knowledge of the parties when they entered into the contract. It's not like it was 6 months ago before we knew of the pandemic. Okay.
Thanks, Patrick. Definitely something that needs very careful consideration, especially given concerns of a potential second wave. I think if I could conclude for everyone, the take-home points of our webinar today for construction firms are they need to look at the furlough scheme and how it will operate as it starts to wind down, and take all concerns in respect of site safety seriously. They need to consider the new mechanisms offered by the insolvency legislation and take advice in respect of any loans or guarantees. They also need to review their title deeds and their corporate needs in terms of office space going forward. They also need to review all construction contracts to ascertain whether or not any reliefs are available as a result of COVID, and take special care when entering into new contracts to ensure further waves are covered. Well, that brings us to the conclusion of today's webinar. As I said from the outset, we hope to bring you food for thought in terms of actions and that you should be considering now as you look to the future and life after lockdown. We hope that you found the session useful. Please remember to access our construction business audit at cleverfultonrankin.co.uk/COVID-19 to highlight the strategic issues you should be urgently addressing. If you require any further advice or assistance on anything covered today, all speakers' contact details are available at cleverfultonrankin.co.uk/people. Thanks very much, everybody.